I know plenty of pregnant people take the VIA bus. Yes, it's hot. Yes, it's uncomfortable. Yes, it's inconvenient, but that's where we are. So instead of doing what you were doing to become pregnant, you should have been getting a job. And I'm assuming she's in yellow because she's expecting. Is that correct?
Yes, Judge, she's expecting in May.
Your fourth MTR that has been filed against you. I don't know what your problem is.
Presence. No, she's in the yellow. She is pregnant at this time, and she is charged with drug offenses, which led me to any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye.
Anthony Cantrell.
And are you Miss Rowley Williams? Can you unmute for me, please?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Dan
Any
Lower.
objection from the defense?
No, Your Honor.
Ms. Rowley, do you have any objections to this proceeding by video?
No, ma'am.
And each of these cause numbers, the defense has filed motions to reduce the bond or request for a PR bond in each of the cause numbers. It's my understanding, defense, you're withdrawing your request for a PR bond in each of these cause numbers?
Yes, Your Honor.
All right.
And I'm not as concerned about the deadly conduct has a $10,000 bond. So I'm okay with that. It's the other case, the ag assault deadly weapon has a $75,000 bond.
All right. So with regards to cause number 2021 CR 11076, are you withdrawing your request for a bond reduction on that matter?
On the deadly conduct, yes, Your Honor.
Okay. So then the only case number we're proceeding on is 2021 CR 10892. State, are you ready to proceed on that motion?
Yes, Your Honor.
All right, defense, it's your motion. You may begin.
Your Honor, on that particular case, we think we have some credible evidence that would be exculpatory to my client. I've shared that with them, but they have not had a chance to investigate that right now. But with respect to the charges and Monique Williams, she's been in jail for quite a while. One of the things I do need to let the court know ahead of time is that we've had, I'm sorry about that phone
Okay, no
behind you
problem.
there. We had filed a motion to have her evaluated, and that was, I think, done quite a while back, Your Honor. And it looks like it was filed, but had not been sent to Judge Carruthers. So we're going to ask that that be done also.
Just one moment. Ms. Ferguson,
Sure.
can you check on the issue with Ms. Williams and her evaluations, please?
Yes, ma'am.
All right, sorry, Deputy Mejia. Everyone, just give me a moment.
So we had filed that. That motion that you're going to be checking on, but irregardless, Judge, and by the way, that motion was filed October 19th. I was just checking.
Okay.
So I've spoke to Ms. Williams. She does not have anywhere near that type of money to bond out. I have no reason to believe that she would not come to court. She has very strong ties in the San Antonio community. She would be staying with her grandmother. Her grandmother has talked to me about trying to get the bonds reduced so that she could come out. So we'd ask the court to consider that. And this is the case that I think we have some very decent exculpatory evidence that we think the district attorney's office will evaluate, because it does have a factor in this case and why it happened.
All right, State.
Your Honor, this case involves the defendant shooting her uncle. Last time we spoke to the uncle back in October, he was still having trouble walking. They shot her one time to the pelvis, and she still suffers from nerve damage. It seems that based on the reports that I've received, that this was an unprovoked shooting. And so at this point, based on the nature of the case and the facts particular to this case, we're asking that the court deny the defendant's motion.
All right, is there any evidence or witnesses from the state? This is what the court is going to do. Court's going to deny the motion. What the court will do is we're going to recall this back, Ms. Rowley, on February 28th. Mr. Cantrell, I'm going to have them expedite the evaluation that she wants done. And if that evaluation has not been done and she has not been seen a doctor, I'm going to reconsider your motion for a bond reduction. But this is what I'll need from you. I'll need the list of somebody that she's going to be staying with because of the concerns that I have based upon State's Exhibit number 1. And if there is some sort of mental health issue, which there appears to be from reading State's Exhibit 1, then I need to know what safeguards are we going to have? Is she going to have a case manager? That type of thing. So if that isn't done by the 28th, the evaluation, we'll have another hearing, revisit this. And if you could make sure that I have that information for the next time.
Yes, ma'am. We'll make sure it happens.
All right, Ms. Rowley, we're going to get that expedited as quickly as possible to make sure that you're interviewed by a doctor, okay?
And Judge, can I go in a breakout room with her
Yes.
out of house arrest so that she can go to work? And then also if we can get the fees on her monitoring waived because she can't afford them.
All right, just one moment.
And she did attend the funeral without any problems last week. So,
Okay, just give me one moment.
Yeah.
There's some paperwork that I have to sign.
I did last week, and you said to set it for a hearing, so I haven't spoken to them today because I guess they're pretty busy right now. I was in breakout room 4 for the last half hour, and I haven't seen anybody yet.
All right. They actually skipped over you. So as soon as they come out of the breakout room from speaking with these other parties, I'll put you in there for them. All right, and why is she in custody?
Judge Angelini did the sentencing on this case, placed her on 10 years deferred adjudication. After the case was, after the sentencing date, the victim in this case asked the state to alter the amend conditions to have no contact with the victim as part of the sentencing. And so that's what we're here for.
So she's in custody because the judge ordered a 180-day jail sanction.
Okay.
And she's going to go into, let's say, the other.
DDR. So you all just asking that there be no contact?
Yes, Judge, it wasn't originally ordered, so it was an oversight on the state's part to ask for a time sentencing.
All right, who is the no contact with?
Judge, I'm sorry, the name's listed in the state's motion. Do you have them?
Oh, thank you. All right, so you don't have no contact with the complainant. Do you understand?
Yes, ma'am.
All right, and there's also an address that's related to that. The court's understanding that Judge Angelini entered the sentence in this case, and the state has filed a motion requesting that there be no contact with the complainant or the complainant's address. Defense, do you have any objections?
No, Your Honor.
All right, then that will be ordered. Ms. Riley Williams, you're not to have any contact with the complainant, nor the complainant's address. Do you understand?
Yes, ma'am.
And I don't know if I don't know if Judge Angelini ordered it or not. But for employment, the court does not allow employments at home as a home healthcare provider or with minors. Do you understand?
Yes, ma'am.
All right, and probation on Ms. Riley, once she's released, I'm gonna want field visits at least 2 times per month to make sure that there are no issues. All right,
One thing that wasn't really clear, Judge, is that if she gets placed in a bed for her healthcare treatment, will that count towards her jail time or not?
if she's in inpatient treatment, yes, it does count towards that.
So she doesn't have to serve the 180 days first and then do that.
Technically, yes, but this is what the court is going to do. Just put her on the list for DGRF as quickly as possible, but she's going to remain in custody until she's transferred to DGRF.
It was my understanding Judge Angelini wanted her to do the 180 days first and then over to DDRF.
Yeah.
So
Let's try to get her to DGRF as quickly as possible.
okay.
All right.
Thank you, Judge.
You're welcome. Because I don't want her to be at the jail if the bed is available, because otherwise they'll pass over her.
Yes.
All right, Mary Diaz, is there something else?
She's asking me this, right? And I think I asked Judge Angelini that she had, how many days back time? 10 months back time, but I think Judge Angelini still wanted her to do the 180 days.
Yes, she's not getting credit.
Yeah.
For the 10 months back time as part of the 180 days. But what I just informed probation is to have you remain in custody and you'll be transferred to DDRF as soon as the first bed is available for you. Okay, thank you. State of Texas versus Monique Renee. Are you okay? Okay. Monique Renee Rowley Williams. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Nick Aguilera on behalf of Monique Ronnie Williams.
All right, and are you Ms. Williams?
Yes, ma'am.
All right, I'm gonna show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Monique Renee Raleigh Williams who was placed on deferred adjudication in 2021 CR 11076 for the offense of deadly conduct firearm on July 11, 2022 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 41, on or about the 12th day of September 2022 in Bear County, Texas, the defendant Monique Renee Riley Williams did then and there fail to conduct herself in a proper and orderly manner and abide by the rules of her grandmother's house in violation of condition number 41.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find violation of condition number 41 true. Is there an agreement?
Yes, Your Honor. The agreement is to deny the state's motion and alter and amend conditions of probation to include that the defendant is not to reside at the residence of Elizabeth Williams and Gwendolyn Williams, who are the defendant's mother and grandmother.
Agreement?
Yes, Judge.
All right, Ms. Williams, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Monique Riley Williams.
All right. Why are you not behaving appropriately at your grandmother's house?
So what really happened is my grandma, she's all about like helping with rent and bills. And I really just got out of jail for 2 months and I'm just now finding a job. And I told her like, I'm trying, but I did have income tax, but I really did need that to buy clothes. And cause when I got out of jail, I didn't have any clothes. I also wanted to start paying all my probation. So I tried to pay my probation officer, but he said to do it the second visit. And also Uber to get back and forth to a job because I don't have a car. So to get
What's
it,
wrong with Via?
it's just been hot. I'm gonna be honest, like I just feel like it's too hot for me to be on the bus. And I'm
How old are you?
21.
So here's the thing. You live with your mom and your grandmother, and I don't know why. Excuse me, you guys are too loud in the box. So here's the thing. You live with your mother and your grandmother, and you got to recognize something. Number one, people think that they can live with their mother and their grandmother for free because, hey, it's my mom and my grandmother. No, you're an adult. You're over the age of 18. You're not in school. You have a criminal case. The fact that your mom and your grandmother are allowing you to live with them is just a blessing on your part. But their rules are their rules. And if you don't want to abide by their rules, you need to live somewhere else. There is no place on this planet that will allow you to live with them for free. If you were to get your own apartment, guess what? They're not going to be trying to hear that, oh, I just got out of jail and this is what I need. You have to pay.
That's fine.
And until you can live up to what you feel your standards are, you're gonna have to take the VIA bus. I know plenty of pregnant people take the VIA bus. Yes, it's hot. Yes, it's uncomfortable. Yes, it's inconvenient, but that's where we are. You understand?
Yes, ma'am.
So where are you gonna be living?
Judge, I just talked to the gentleman. He lives at 3112 Brookshire Drive in Plano, Texas. His name is Richard Smith. Richard, although his lease expires in a month, first part of November.
Well, who is he to her?
Oh, he just told me he's the daddy of the baby.
Is this the father of your child?
Yes, ma'am.
Well, he doesn't have a stable place to
But
live.
he's staying there until the lease is up, and it's the first week of November, then he intends on coming to San Antonio.
Okay.
That's what he just told me like 10 minutes ago, maybe 20 minutes ago.
Probation.
Yeah,
Is there any other housing available for her? For pregnant with Cross Point? I think Cross Point has a place for pregnant women.
I could call Cross Point, and then there was one other housing situation that Judge Zumba used to use.
Oh,
It
that
was
is
with,
Miss Jackson.
yes, Ms. Jackson.
All right, so I'm gonna see if these other places are available for you. You need to get your life together and not be dependent on someone to take care of you.
Yes, ma'am.
Because at any moment when when you're dependent on someone to provide the roof over your head, they can say, tired of you, bye.
Yes, ma'am.
All right. So I'll deny the motion. Alternate amend conditions. And how far along are you?
The Bear County told me I was 5 weeks.
All right, so here's the thing, and I don't understand, and people can do what they want to do. But to me, you should have been trying to take care of yourself instead of, that's probably another one of your grandparents, your grandmother and your mother's problem is that you're living with them and you're bringing another mouth to feed. So instead of doing what you were doing to become pregnant, you should have been getting a job. You understand?
Yes, ma'am. I just started working at a Econo Lodge. And I promised my grandma that my first paycheck, when I first get it, I was gonna give her some money.
But here's the thing, you're working at a Econo Lodge, you're 5 weeks pregnant, which means you're not going to be at that job getting a paycheck forever because you're going to go to the hospital, you're going to deliver the baby, and somebody's going to have to take care of the baby. Then the baby's going to need money for daycare unless you are planning on being off with your baby. Then there's going to be a worry because who knows what happens to babies at daycare because they can't talk and tell you what's going on. So you just made your life very difficult. And babies are great. I love babies. But now you have to put your baby first and you can't be hopping from home to home. So this guy who you say is the father of the child, I mean, I don't know. Nobody will know till DNA test is done. But he doesn't even have a stable residence. Your attorney is telling me he's there till his lease is up in November, then he's moving to San Antonio. That's not planning. Planning should be, my lease is up in November. The mother of my future child is at the Bear County Jail. I'm gonna already have housing set up so she'll know my lease is up November 1st. November 1st, this is where we're gonna be living. He doesn't even have that plan done. You understand? All right, so I'm gonna deny the motion, alternate amend conditions to include parenting classes, and we'll do a referral to Cross Point and with Miss Jackson's home. I don't know if it's Victory Home for Women.
I really can't remember the name. I'll find out, Judge.
All right, is there anything else you need from the court?
No, no, ma'am.
All right, and you're not allowed to, well, you're not allowed to reside with Gwendolyn Williams and Elizabeth Williams. For now, you all may end up working things out. They see their grandchild, they fall in love, they want you there. You understand? All right, is there anything else? All right, good luck to you. You're gonna have a baby coming in, so you need to do better.
Yes, ma'am.
Review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney. Did you understand it?
Yes, ma'am.
Are you the same Monique Renee Raleigh Williams who was placed on deferred adjudication in 2021 CR 11076 for the offense of deadly conduct firearm on July 11, 2022 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
In Bear County, Texas, the defendant, Monique Renee Riley Williams, then and there failed to submit to drug testing for the month of March 2024, as directed by the court officer, supervision officer, and or duly organized, authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, the state waives and abandons the other conditions.
Any objection?
No, Judge.
Did you understand by pleading true to violation of condition number 2, the court can find it true, grant the motion, find you guilty, sentence you to 10 years in prison,
Yes, ma'am.
knowing that you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court is going to find violation of condition number 2 true. Is there a proposed agreement?
There is a proposal, Your Honor, yes.
And what is that proposed agreement?
The proposed agreement is to follow the recommendation of probation, which is amend conditions for continued CPS compliance, bid class completion, and a no harmful or injurious contact with the defendant's child's father.
And what's the name of the father?
Jarrell Sinquist.
Darrell what?
Jarrell Sinquist.
Spell the first name.
Jorel, Sinquiz, Senquiz. Yes, please.
All right, why are you not, you want to raise your right hand for me, please?
Yes,
Do
ma'am.
you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Monique Riley Williams.
Why are you not being successful on this probation? You're supposed to report for UAs, you're not doing it. Why not?
I missed this one. I'm gonna be completely honest. I had forgotten. I don't do drugs or alcohol. I've never came out dirty, so I did ask him to if I can do one that week and he told me yes, so I did 2 for the next month.
All right, is that correct probation that she did 2 for the next month? All right, if you need to get a calendar, you're gonna have to get a calendar. You're looking at 10 years in prison.
Yes, ma'am.
You understand?
Yes, ma'am.
All right. Any other recommendations?
No, Your Honor, that's the entirety of the proposed recommendations, Your Honor.
All right, I can tell you with regards to Jorel Sinquez, I'm not gonna do a no harm for injurious contact until he provides a letter to probation or comes and tells the court that he wants to have contact with you. There's a reason why people are asking for no harm for injurious contact. So the court is going to deny the motion, alter the main conditions to include CPS compliance, the BIPP course, and there's to be no contact with Jarrell Sinquez. And if there's an issue, obviously there is an issue because it's CPS, so there's a child involved. If there's an issue with child exchange while the CPS case is pending, they can help make that happen without your contacting him. You are not to have contact with him. Do you understand?
Yes, ma'am.
That means no phone calls, no letters, no, I'm sorry, no, let's try to work this out. No, what's happening? Do you understand?
Yes, ma'am.
All right, is there anything else you need from the court?
No, ma'am.
Probation, is there anything else she needs?
No, Your Honor.
All right, we can go off the record. Here's just some side advice that I used to always tell my clients on CPS. When you break up with somebody and you are no longer together, they may tend to bring other partners in your child's life that you think they should not be. What you need to do is contact your attorney, or in your case, contact CPS. But you are not supposed to be putting your 2 cents in that relationship. And whatever you do, if this no contact order is ever lifted and you all are doing child exchanges, don't bring your significant other to the child exchange. And if they bring their significant other to the child exchange, just bite your lip and accept it.
Yes, ma'am.
Because crazy things end up happening when people are bringing girlfriends and boyfriends who really have nothing to do with nothing to a child exchange. Do you understand?
Yes, ma'am.
All right, good luck to you.
Judge, she did want to ask, she's got her diploma. and She
Ah.
wanted to ask if that would help with her community service.
Yes, let me see. This is
I'm enrolled in
awesome.
College.
And she starts college in August.
Oh, yes, of course that will help. This is great. You know, I ended up going to Booker T. Washington High School.
Yes, ma'am.
The other schools that had more money than our school had, they did not have the leather binding. And my mom would tell people, hey, where's your leather binding? My daughter has leather binding. But, oh, this is so awesome. I'm very proud of you.
Thank you.
And so what are you going to study? What are you doing in college?
Phlebotomy, hopefully.
Okay, awesome. I can't do that. Don't like the sight of blood, but all right. Well, good luck to you. Just keep striving. And sometimes when you're striving to do different things and better yourself, it's difficult. It gets hard, but don't lose sight of what your hopes. Approach and announce for the record for the state,
Jason Garrett, Your Honor.
for the defense.
Nick Aguilar on behalf of Monique Williams.
All right. And are you Miss Williams?
Yes, ma'am.
All right, defense is here requesting a bond. And this case number, she's on deferred adjudication. She's entitled to a bond. Have you all come to an agreement?
Yes, we have you on. Or
We have no problem.
something.
All right,
They recommended a 40 and I anticipated that it would be a 40 and informing the family based on the circumstances.
so are you all in agreement then?
Yes.
Yes, Your Honor.
All right. The court is aware of the defendant's history based upon the fact that she's on deferred adjudication in this court. So therefore, the court is aware of any mental health and medical issues. The court will set the bond at $40,000. The court is going to order partial GPS, waive fees. And I'm assuming she's in yellow because she's expecting, is that correct?
Yes, Judge, she's expecting in May. And I understand it's, she just used the word high risk.
Okay. So it'll be partial GPS waive fees, and that'll be for medical appointments.
And then she's also a student at Palo Alto.
Is she going to be continue doing that? Well, is she enrolled currently?
She's enrolled. She turned herself in on this matter Monday afternoon and hope to get this, get in and get a bond set so that she can continue at school and help appointments.
All
She
right.
did not wait to get picked up. She turned herself in.
All right. Do you have any objections to the court allowing her to attend classes?
No.
All right. All right, for medical appointments in school. Is there anything else?
And of course, we can get attorney visits, right? To the attorney office.
Oh,
Yeah,
that goes
that's-
without saying. If
Sure,
they want
sure.
me to add that, that would be very strange.
That would be very strange. Thank you.
All right,
Judge.
let me give you a setting.
Daughter's visit.
Oh, she has court next Wednesday. Tuesday or Wednesday. It's an official court setting with CPS.
Okay.
There shouldn't be any problem with that either. Right?
No, they'll let her go to court.
She just wanted to make double sure.
Yeah. So I'm gonna recall this back for October 17th. Why are we filing this motion to withdraw? State, why is the motion to withdraw being filed?
Present the question
Yes.
to the state. It's due number one, Judge, they're not indicted. One's family violence, that's gonna be dismissed, my understanding. But there's two other ones that are ag assaults, have not been indicted. I did inform the defense that we may refile, but at this point, we can't be proving it on an MTR.
All right, and where are you working? Why do you have this badge on?
It's a school thing.
I'm sorry?
It's a school. It's for school.
Oh, okay, because I was like, I hope that's not a badge for a home healthcare provider because I don't allow that.
No, it's a school thing. It's at I think it's at St. Philip's,
Um,
Palo Alto. I was wrong.
All right, so they're filing this motion to withdraw basically because your cases haven't been indicted yet. This is your fourth MTR that has been filed against you. I don't know what your problem is, but what I do know is the charge you have, you're looking at 10 years in the prison. So if you want to continue on this path, I'm going to tell you what I told everybody else. Just because you're a woman does not mean that they don't have a place for you at the prison. They will make room. And if there are only supposed to be 10 people in a cell, I guarantee you, they're not going to let you run around out here and saying, oh, federal law says only 10 people can be in a cell. So we're just going to let people run amok. They will find and squeeze you into that cell or either leave you in processing. Do you understand?
yes, ma'am.
Do not come back here with nonsense before this court. Do you understand?
Yes, ma'am.
And these new number ones, who are the complainants?
They're non-family, Judge.
I can find out, Judge.
All right, because she's not having contact with those persons.
But we have no contact with them now. That was part of the bond conditions on these new charges.
Right, so the family violence, the VPO case arose out of the ag assault cases, but because the ag assault cases are not family violence, the elements of VPO are not attached.
slides. Get it done.
Okay.
And Judge, as a condition of her MTR bond and the ag assault bond, she's on partial house arrest GPS. She does have a CPS case open where she gets supervised visits with her child through CPS at the CPS office. It's like on a Wednesday, every Wednesday. If you could approve Ms. Williams attending the CPS office to visit her child, her children. And then it might be a stretch to ask, but I'm going to anyway. If she could also take part in any doctor appointments or medical appointments for the children.
Well, once that happens, she can come forward and ask, because unless the children have some sort of chronic issue, usually those appointments are scheduled.
Sure.
State, do you have any objections to her being allowed to attend child visitation with CPS supervision? All right, I'll sign the motion to withdraw. And counsel, you'll need to, write an order with regards to this, child visitation.
Sure.
Is there anything else?
No, Your Honor. We appreciate your time.
All right, thank you.
May we be excused?
Once you speak with probation.
Judge, so
Oh, and probation, is there anything you want added? Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, briefly. With regard to my clients, upon myself first meeting her, and our first visits, I knew there were some issues present. She's in the yellow. She is pregnant at this time, and she is charged with drug offenses, which led me to believe that there might be issues with substance use disorder, Your Honor. I did also see prostitution in her criminal history, so I did take it upon myself to ask the court previously, which was granted, to have her referred for Esperanza Court. I know Esperanza Court does great work. I've worked with them some times in the past, and they have evaluated her, deemed that she does meet criteria. And an email from Ms. Perez, Natalie Perez, the case manager, stating that if the court would consider granting her with the condition of Esperanza Court, that they are willing to accept her into that program, Judge. So I spoke with my client and explained the Esperanza Courts, the criteria that has to be met to get in, and what would be expected of her if she is in the program. And she is willing to abide by that. She wants to change her life around, not only for herself, but for her unborn child and for children she has as well, Judge.
All right, how many children do you have?
I have 3.
And who are they with?
I gave up my daughter for adoption and my son's with my stepfather, and then I'm pregnant right now.
All right, and who is this Antonio Pablo?
That
Hernandez.
is my kid. That's my first kid's father.
All right. So I'm ordering no contact with Pablo Antonio Hernandez. And that's based upon what's in the police report. Take in consideration 2024 CR 009697, 2024 PF 17269, 2024 PF 17270. There'll be a referral to Esperanza Court. She's to remain in custody until transferred. Regular reporting by Zoom or in person, regular random UAs. If not accepted into Esperanza Court, then I want her brought back to court. So she is only to be released to Esperanza Court. When's the last time you had employment?
I have my own lawn care business.
Right, everybody's doing lawn care. Yeah, let me just tell you, that's gonna stop. You're gonna have to have a business. You understand?
Mhm.
And when I say a business, if you're doing lawn care, you need to have a DBA and all of that. Otherwise, I'm not accepting that. You're gonna have a job where you actually get a W-2 or whatever. You understand?
Mhm.
So there's gonna be
Yes,
proof
ma'am.
of employment within 45 days. There's to be no employment as a home healthcare provider or with minors. CPS compliance. Is CPS back in your life? They probably will be, counsel. I'm gonna want field visits 1 time per month until further notice. There's to be 200 hours of community service restitution. I'm gonna order parenting classes. Once parenting classes are completed, the restitution will be deemed satisfied.
That restitution, Judge, is that 200.
200 community service hours restitution. There is to be 2 years in the prison, suspended and probated for 4 years. Probation, is there anything else? Is there anything else you need from the court to be successful?
This, the Esperanza program.
All right, did you review the document titled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
Thank you, Your Honor. Have a good day.
Just 1 second. All right, court is calling 2024 CR 004-712, State versus China Gonzalez. Could I have parties announced?
Megan Galloway for the state.
Michael Bellable, Mr. Gonzalez.
And are you Ms. Gonzalez? Counsel, have you received all discovery?
I believe I have.
And did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, did you review entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Your Honor, we move to proceed on the lesser included offense of possession of controlled substance, PG1 less than 1 gram to the state jail felony offense.
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance? Penalty group 1 less than 1 gram, that's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 less than 1 gram. They're asking that your punishment be assessed at 235 days in the Bexar County Jail under 1244. There's an $800 fine. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Then to the offense, the lesser included offense of possession of a controlled substance, penalty group 1. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer state 1 in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. And the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Ms. Ryan, Ms. Gonzalez has asked to follow the plea bargain there.
All right. If you're drug tested today, what are the results going to be? And no, you will get drug tested today before I enter sentencing.
That's fine. I'm clean.
All right, let's have her drug tested. All right, you're gonna,
I do go to a methadone clinic though, but that's it.
okay.
Go to Oaks.
Is Child Protective Services involved?
Yes, they are, and I'm doing everything. I'm being compliant with them. I'm on my way to getting my case closed.
And who's the attorney for the children? Do you know?
I don't have an attorney. It didn't get that far.
Oh, so it's family based?
Yes,
And are the children staying with you?
yes. That's fine.
And how often is the caseworker coming to see you?
She comes every 2 weeks, but I am also in the Esperanza program. I get drug tested every week. I have to go drug test today.
Oh, you're in Esperanza?
Yes, ma'am.
That's not my,
All right, state or Ms. Ferguson, can you look to see? She says she's in the Esperanza program.
Oh,
So they don't show that you're in Esperanza Court. In Bear County?
yes, with Stephanie and tourist stop.
All right. I believe that's Catherine
Oh,
Torres.
cousin.
So,
Sorry.
counsel, before I enter the sentence, because now I have a little red flags going on.
I
So
understand.
if you could check with that court to see if she's actually in Esperanza Court. That would help the court make a decision on this. So just have a seat. He's gonna, if
Okay.
you go to Judge Stahl's court.
I will run down there right now.
All right, thank you. And then we'll come back and take care of this.
It's my understanding, Judge, and I think the state checked into this also. Felony drug court, she was in phase 5. They checked into that. What that is, that's the aftercare program. If the court takes notice, the last drug test was back, I want to say 30 it was either September or October, the October one. We don't know if she's pregnant or not. She may have miscarried. They will find out this week. Having said that, Judge, we would like some form of outpatient treatment, maybe weekly UAs. It's like like I told the state, you're running the 440-yard dash, you make it to 435 yards, and then we don't quite complete it up. Now we're gonna have to start another 9-month program. At the time this happened, her father had just passed away from cancer. She was trying to take care of the estate and stay in his house. It became overwhelming for her at that point in time. I think that's where she got off track.
So here's the thing I know about felony drug court, because I used to be an attorney for felony drug court. All you had to do was pick up the phone and call them.
I actually did ask them for help. I asked them if I could ask alumni for help with my father's funeral. I even asked if I could put his fundraiser out there. And the case manager at the time, CJ, denied it. She didn't even let me bring it up to alumni.
But now here's the thing, it's not about whether or not you can do a fundraiser, it's about, I'm struggling because I have all of this hitting me at once. I'm struggling in the sense that I may not do my UAs, I may fall out of this program. That's what it's about. It's not, I'm struggling, I've asked you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just gonna stop submitting you to drug testing. I'm not gonna do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye. I didn't get that, and I tried to work with my case manager. I did good the whole time I was on it.
So let me ask you this. Here's the question. You asked for your case manager. You tried to work with your case manager and it wasn't working. So your response to that was to do what with your probation?
At the time I was with someone, I had too much stuff going on. I was losing
Right,
my
so
father's house.
your decision with probation was what? With felony drug court? See, I'm trying to get you to point, because see,
Well, I know where I messed up. I'm not saying I didn't.
yeah, but so that's the thing. You didn't learn anything from felony drug court, because let me just explain something to you. Everybody in this court has a bad day. Now, some may have a bad day that is not as bad as others. Let me just tell you what happened to me. I had a client who was on parole. I had a parole hearing scheduled for them. You can unfold your arms. I had a parole hearing scheduled for them. I knew that they had mental health issues, and I knew that they were depending on me to be there for their parole hearing. All right, so I'm sleeping, everything's going well. I get a call at 3 a.m. It's a Monday. I get a call at 3 a.m. And you know what that call is? It's from my younger brother. And guess what he tells me? Grandmother died. Now, what do I do in that situation? I know I got a client who's expecting me, who has mental health issues, who maybe won't understand. I know I'm an attorney for children on CPS cases who are not going to understand. So do I just throw my hands up and say, you know what? This is what's going on in my life. I'm not calling anybody. I'm not doing anything. You all handle it. See you later. It's called adulting and growing up. So what did I do? My mom, of course, was upset. She's like telling my brother, why didn't you call her? You know, it's late. She's far away. She's all the way in another state. But I went and I did the parole hearing because that person was depending on me. I went and visited children because they were depending on me. And then I got a flight and left for home. And I left message to everybody, hey, my grandmother just died. I'm going to have to go home. So I tell you that to say everybody has problems in this world, but your problems in this world, you're supposed to be able to deal with that. And dealing with that when you're looking at 20 years in prison is to, when somebody says, no, we're not going to do that, then you got to accept that. You're on paper. That's what we called it when I was a defense attorney. You're on paper, you're looking at 20 years. So here's my question. Is the TAP evaluation updated or no?
Your Honor, the TAP evaluation I have from probation is from 2021. I do not see, I don't have any information.
All right, so we need an updated TAP evaluation. So I'll find number 2 true. I'm gonna give you a choice. I can deny the motion. You're not getting out of jail today. You're gonna do the TAP evaluation in custody. If the TAP evaluation says you're going to inpatient, you're going to inpatient. Or what I can do is I can revoke you and I'll give you 3 years. Those are your choices.
And how long does the TAP evaluation take?
It won't be long. I think that's the right choice.
Will I get my back time if I sign up?
Sure.
Client is 4 months pregnant at the current. I asked the court to follow the recommendation of the state, which is deferred adjudication in this case. It'll give us a 4-year window of time in order to make sure that she stays off of drugs and stays on the narrow path.
All right, so what's happening with your CPS case?
It's still going. I just finished one class and I'm currently on drug tests and, I'm doing good with that, with those 3 months. And once I, do eventually get out, like I'm still gonna do, those 3 other classes
How
that
many children do you have?
I have 2,
What are their ages?
4 and 2.
And how old are you?
I'm 24.
All right. So here's the issue with the court, right? I'm going to follow your agreement, counsel.
Thank you.
But this is what you need to realize. You already had a CPS case pending
Yes.
and you pick up this case. And according to the person who was trying to help you, you've been drinking alcohol at that time and still using drugs. Do you have any idea what drinking alcohol and doing drugs does to your unborn child?
Yes, ma'am.
Well, let me ask you this, because people say that and they really don't internalize it. Let me ask you this. You're a 2-year-old, you're a 4-year-old. Would you let them drink alcohol?
No, ma'am.
Would you let them do meth,
No,
heroin,
ma'am.
or anything?
Mm-mm.
Well, guess what? Your unborn baby, you're giving that child alcohol, you're giving that child drugs. That has to stop. Because I've done CPS cases before and I represented children before.
I'm sorry.
And you know what ends up happening when children are born addicted to drugs? they go through withdrawals. Have you ever gone through withdrawal?
No.
All right, well, let me just explain to you what ends up happening. What ends up happening is babies are in pain because they're going through withdrawals. They are craving what you've been giving them, alcohol and drugs. They have shakes. They are just constantly, it looks like seizures, and they are in major, major pain. So you're going to have to change your ways. If you do not, what's going to end up happening is you're going to lose custody of all your children.
That's
You
fine.
understand? Now, if you don't want to be a mom for them, you can sign your rights away.
No, ma'am, I have all of my rights.
All right. So that's what I'm telling you. You had better start looking out for more than yourself, because guess what? Your 2-year-old and 4-year-old, you can't just send them to Travis Park and say good luck to you. And when you are using and you're not clean and sober, guess what? You are sending them to Travis Park and saying good luck to you.
Yes,
That's
ma'am.
the equivalent of what you're doing. So you're going to have to change. You understand?
Yes, ma'am.
All right, the court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine. It will be probated. There's an affirmative finding of family violence. Take in consideration 2024 CC 736223, 2024 CR 009623, County Court Cause number 731512. There's to be no contact with Alice Martinez and Marina, Marina, and Zildua. They're asking for anger management, probation. I really think it's the drugs, because it appears that at the time of the offense, she was high on something as well as alcohol. So I'm not going to order anger management now. I'll hold it in abeyance. In probation, if something comes up and you feel she needs anger management, then we'll do anger management.
You understand?
Yes, Your Honor.
And
Thank
if you
you.
want anger management classes, you let them know.
Okay.
All right, there's to be a TAP evaluation in custody. Follow Rex. And I'm going to want a referral to felony drug court in custody. And counsel, if CPS has them in their drug court program, then I'll reconsider felony drug court. But for now, it's felony drug court. There's going to be 80 hours of community service restitution. I'm going to order parenting classes. Once she completes parenting classes, that will be deemed satisfied. Probation, if you can make sure that there's no overlap between what I'm asking for and what CPS is asking for. CPS compliance. Proof of employment within 40 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month until further notice. And 120 sober meetings in 120 days. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, Your Honor.
Did
Thank
you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. This is your chance. Everybody's giving you a chance to be a good parent, to be in your children's life.
Yes, ma'am.
From here on out, whatever you do, you need to be thinking about 2 things. 1, is this something that could potentially result in me going to prison for 10 years?
No, ma'am.
You know, is this something that could potentially result in me losing custody of my children? If the answer is yes, then you should not be doing it. Do you understand?
Yes, ma'am.
If you need anything, just let the court know.
Yes, ma'am.
All right, you're
Thank you.
excused. Thank you.